Today, we're talking about one of the most misunderstood parts of real estate risk management, the difference between an incident, a claim, and a lawsuit, and why waiting to report a problem can become a very expensive mistake. What is an incident? Now, an incident is a situation, mistake, disagreement, or warning sign that could reasonably lead to a claim, even if nobody has demanded money, hired an attorney, or put anything in writing. The tell is simple. Something has changed. Maybe a client suddenly becomes accusatory. A buyer says, "You should have told me about this." The seller claims the agent mishandled an offer. Someone repeatedly asks for documents, threatens to contact the licensing board, or says they're exploring their options. There may not be a formal complaint yet, but the agent should be thinking, could this reasonably turn into a demand, a regulatory complaint, or a lawsuit? If the answer is yes, or even maybe, you may be looking at an incident. The first complaint is not always the first warning sign. What should an agent do immediately? First, notify your broker or your boss or whoever is designated to report issues to. An agent should follow their brokerage's reporting procedures rather than trying to manage the situation alone. Second, you have to preserve everything. Emails, text messages, transaction documents, disclosures, inspection reports, photographs, notes, voicemails, electronic records. Like I said, everything. Do not delete anything. Third, write a factual chronology while the details are still fresh. Record who said what, when it happened, and what actions were taken. Stick to the facts, not opinions, not blame or speculation. Fourth, notify the insurance professional or carrier as required by the policy. Reporting an incident is not an admission of wrongdoing. It gives the appropriate people an opportunity to evaluate the situation before it grows. The reporting clock matters because many professional liability policies are claims made. Coverage can depend on when the matter was first known and when it was reported. Early notice gives you options. Late notice can take away those options. Now, when does an incident become a claim? Many agents think a matter becomes a claim only when a lawsuit is filed. That is not necessarily true. The basic definition of a claim is a demand for money or service. Now, depending on the policy language, a claim may include a written demand seeking money, repairs, reimbursement, contract cancellation, corrective services, another form of relief. A letter from an attorney is an obvious example, but it does not have to come from an attorney. An email from a buyer saying pay $25,000 to repair the foundation or I'll take further action may constitute a claim. A demand to pay for mold remediation, replace a roof, compensate someone for an alleged loss may also qualify. A courtroom filing is one type of claim, but is not the starting line for every claim. What changes when a lawsuit is filed? Once a lawsuit is filed, the process becomes formal and deadline driven. The agent or brokerage may be served with a summons and complaint. That means there is limited amount of time to respond. The documents should be sent immediately to the broker, insurance professional, and carrier. Do not contact the plaintiff or their attorney to explain, argue, negotiate, or even apologize. The carrier will evaluate coverage and, when applicable, assign a claims professional and a defense counsel. The defense attorney represents the insured and begins collecting documents, interviewing the people involved, analyzing the allegations, and preparing the formal response. The agent may participate in attorney interviews, document production, written discovery, depositions, mediation, settlement discussions, trial preparation. The agent's job is to cooperate, preserve information, remain truthful, and let defense counsel direct the legal strategy. Defense is a team process, but the team works best when it receives accurate information early. The mistakes agents make repeatedly. The recurring mistake is waiting because they think it isn't a claim yet. Agents hope the problem will disappear. They worry that reporting it will make them look guilty or automatically increase the brokerage's insurance costs. Meanwhile, emails continue, positions harden, records disappear, memories fade, and the opportunity for an early resolution may be lost. The agent may even respond emotionally, admit fault, offer payment, or promise repairs without authorization. Waiting does not make the exposure smaller. It usually makes the defense harder. Notice is not admission. It is protection. Documentation habits agents need to know. Good documentation begins before there is a problem. Say something like, "Thank you for speaking with me. This email confirms what we discussed and the decision you made." Document recommendations that a client accepts, and especially those the client rejects. If a buyer declines an inspection, document. If a seller refuses to disclose something after being advised to do so, escalate it to the broker and document the conversation. If the client chooses an offer based on factors other than price, record the instructions and reasoning appropriately. Agents should consistently document client instructions and decisions, property condition discussions, material disclosures, inspection recommendations and waivers, offer presentation and rejection, wire transfer verification, repair negotiations, deadlines and extensions, conflicts or unusual circumstances. Keep communications professional. Write every text and email as though it could eventually be read aloud in a courtroom. Your documentation does not need to be dramatic. It needs to be timely, factual, and consistent. What if something happened weeks ago and wasn't reported? Don't panic. Do not wait another day. Notify the broker and the insurance professional now. Explain what happened, when you first became aware of it, what communications have occurred, and whether anyone has demanded money, repairs, or another remedy. Preserve the original records. Do not backdate notes, alter emails, or try to clean up the file. Late recording may create coverage complications depending on the policy, but continued delay only makes the situation worse. The best move is transparency, documentation, and immediate action. Here's the message I want every real estate professional to remember. An incident is a warning. A claim is a demand. The lawsuit is the formal legal action. Do not wait for one stage to become next before asking for help. Recognize it, preserve it, report it. That is how you protect yourself, your brokerage, your clients, and your reputation. Protect, prevent, prevail.